SJC-13432, Commonwealth v. David E. Canjura.
Okay, Attorney Gerber, whenever you're ready.
Good morning, Your Honors, and may it please the Court. Caitlin Gerber on behalf of David Canjura. This case presents a Second Amendment facial challenge to the ban on carrying a switchblade or spring-assisted knife under Section 10b of the General Laws, Chapter 269. Now, our analysis in this case is guided primarily by the two-pronged test articulated by the U.S. Supreme Court in Bruin. Prong 1 asks whether the conduct in question falls within the plain text reach of the Second Amendment, and if so, it is prima facie protected by the Second Amendment.
Should we give the government a chance on remand?
So I don't know that that's necessary in this case, and there's a couple reasons why. The first is that Bruin itself did not remand for the type of determination that we...
I read the Ninth Circuit case as well, and they said, what's the point of a remand? But it seems we get one side of all the history from the very good amicus briefs that we've gotten and from your brief, but we don't get the other side, perhaps, of history, which I don't know what there is.
So it does seem, I would just point out that all of the parties in this case briefed with full understanding of the Bruin test. I mean, all the briefing was completed after Bruin, which was also the case in Teeter v. Lopez. I believe that there were several other Ninth Circuit Second Amendment challenges pending at the time of Bruin, and those were all remanded because I think they were briefed and argued prior to Bruin. Teeter was the one case that was stayed and then rebriefed in light of Bruin, and so that was part of why they didn't remand. And here, although it is true that the trial court decision occurred prior to Bruin, all of the briefing has occurred in light of the Bruin standard, and respectfully...
I know what national historic tradition means. I don't know whether regulation after 1868 counts, and we've got a lot out there. That Northern District of California case had exhaustive testimony. I will tell you, for one, I do not know what national historic tradition means, and if we can consider regulation after the 14th Amendment or not. Maybe you do.
I can't say for sure what the Supreme Court was thinking. I think that the rationale in Bruin makes it pretty clear that the most relevant time periods for the historical regulations being considered are the time that the Second Amendment was drafted up until the 14th Amendment was drafted.
Should we just wait them out and see what they do in the domestic violence case to see if Bruin goes away?
I mean, we could very well wait and see what they do in Rahimi, but I don't think that's necessary here for a couple of reasons. The first is that...
I was being facetious. You probably picked that up.
I am curious where that case will go. But in this case, which is a different arm and a very different situation, there's a couple reasons that I think that's not necessary. And the first is that these really aren't the type of facts that a fact finder needs to find at trial. So, you know, as opposed to, for example, Guardado 2, where the Commonwealth now, there's a new rule where the Commonwealth needs to introduce additional evidence to prove an element beyond a reasonable doubt. Here, what we're looking at is essentially statutory interpretation and legislative history, which are well within the purview of an appellate court. But
what's the legislative history? Are we confined to Massachusetts? Does it matter that folks in Wyoming in 1867 might have had a little bit of a different view of whether you needed to have whatever the closest thing to a switchblade was then?
Well, this is a challenge under the Second Amendment to the federal Constitution, so I do think a national...
Okay, so I don't... Okay, I agree with you. And I might have a view of how people in the Boss Wash corridor feel about this, but I'm not so sure how folks in Montana might have felt about it in the aftermath of the Civil War and maybe before the 14th Amendment.
Is it your position that it was incumbent upon the government, whose burden it is, to show that the infringement of the Second Amendment right to bear arms, that they had the chance to marshal their arguments in the brief post-Bruin, and so this is the record, and this is the record that we should decide on?
Yes, that is my position.
Okay. Okay, so who has the burden to show that under prong one, that this is conduct covered by the Second Amendment?
You know, I'm not fighting the hypo, I promise. Burden is a strange word only because I don't think the Supreme Court ever used the word burden to describe prong one, but I do believe it's the
I
appellant.
agree with you, but the amici have taken a position that it is the burden on the person asserting the Second Amendment right to show that this is actually an arm and conduct covered by the Second Amendment, and I'm giving you an opportunity to respond.
Yes, I think setting aside the question of whether this is truly a burden, even if it is, I believe we've met that in our briefing. And the reason I say that, and it does seem that this really is the main point of disagreement between the parties, but the definition of arms within Bruin, and really Heller, I think is quite clear. It's the historical definition, although it may be applied in present context. Weapons of offense or armor of defense, to quote one 1771 dictionary, or anything a man wears for his defense, takes into his hands, or uses in wrath to cast upon another. And Heller makes it very clear that although Heller is about firearms, it's not limited to firearms. And the reason we know that is because just after those definitions, it cites another 1797 example about bows and arrows. So I think from its text, Heller contemplates a broader protection than merely firearms. Heller defines arms and defines the Second Amendment's protection of those arms as they were at the founding, but notes that weapons in common use are not the only ones protected.
Well, we found that out the hard way in the stun gun case.
That is one way of phrasing it, yes. Stun guns are electrical weapons, so they are not firearms, but they are nonetheless protected.
So you're saying the weapon doesn't have to be in common use? Can you explain that?
Yes, so I did note, I think the Attorney General's brief takes the position that it must be in common use today
For self-defense.
for self-defense. And I don't believe that I don't believe that's a requirement. I think that's a ceiling, but not a floor. So looking at Heller and Bruin, the relevant definition is it an arm, applying the historical definition? And even if it's not, if it is in common use today for self-defense, it can also be covered. But it's not required.
Your position is that with regard to switchblades or spring-loaded mechanism knives, we don't have to reach that because whether the test is in common usage today for self-defense, you've already met that with the evidence that you've submitted? Or would we have to send it back for you or for somebody to marshal some evidence on self-defense?
I think we've provided sufficient evidence that it constitutes an arm for purposes of the Second Amendment. I don't believe it's a requirement that it be in common use today for purposes of self-defense.
So, but if we disagreed with you, we'd have to remand.
I don't think you would, because this is a facial challenge to the statute, and again, the type of evidence that we've presented is largely historical.
But does your evidence, and I haven't looked at all of it, so you know more than I do at this point, does your evidence show that switchblades were in common use for self-defense?
It shows that their precursor, which was spring-assisted folding knives, were in common use for lawful purposes, which I think is the correct formulation of the test, which includes self-defense or carrying in self-defense, but is not limited specifically to self-defense today. And I'm happy
Counsel,
to point.
I'm a little bit confused. I thought you melded two things there that you previously had separated. For purposes of the analysis, are you saying that there is a look modern day as to whether or not switchblades are in common use for self-defense? That not necessarily that it was an arm historically, that it would have fallen under the definition of an arm. But I thought you said a few minutes ago that under the modern day view, you'd look to see whether or not it's currently being used for self-defense.
So that is not a requirement, and I apologize if I wasn't clear. I think that is essentially a ceiling on the arms that are protected. So any weapon that falls within the historical definition, essentially weapons of offense or armor of defense, would be protected, but that is not limited to arms in existence at the founding, as Bruin.
Can I just play that back to you, make sure I understand what you're saying?
Of course.
You're saying, yes, if something is used for self-defense today, it's protected because the Constitution's an organic document. but that the Second Amendment protects a lot more than that.
Essentially, yes. I think the wording that the Bruin court used was, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, even though the Second Amendment's definition of arms is fixed according to its historical meaning, and that's in reference to Heller's definition, that general definition covers modern instruments that facilitate armed self-defense, much like the First Amendment also protects modern forms of communication, or the Fourth Amendment applies to more modern forms of search and seizure.
That's what I thought you said. So going back to Justice Wendland's point, because that's the reason why I thought there was a lot of appeal to the Attorney General's brief. You gave us a lot of numbers in terms of how many switchblades are in the stream of commerce, but it doesn't answer the question about whether or not they're in common use for self-defense. Just because there's a whole lot of switchblades out there doesn't mean that there are a whole lot of people carrying them for self-defense. It's a very different question. So wouldn't that benefit from giving the Commonwealth some opportunity to marshal evidence as to whether or not that is or is not true?
Well, I don't think that is the Commonwealth's burden. I think that's technically my burden, understanding the vagueness around the concept of burdens on prong one. But respectfully, I think, and I'm happy to speak more to the historical context, I think that we have met that burden on appeal, and the Commonwealth has not responded in a way that would overturn it. I mean, the Commonwealth...
Well, it's not an evidentiary hearing, though. This isn't, that's the whole point of why we're saying that perhaps a remand might be more of usefulness than maybe the Ninth Circuit thought. I mean, this is not an evidentiary hearing. The fact that you put it in your brief and they didn't respond to it, right?
That is true, although I think it falls within the reign of legislative history, which is certainly within the purview of appellate courts. Given that these are not, because it's a facial challenge to the statute, an evidentiary hearing might address the historical record or, additional facts about history, legislative facts, as the Ninth Circuit phrased it. But it doesn't change the fact that the statute still absolutely prohibits the behavior. This isn't evidence sufficient to support a conviction such that the government needs to introduce it for the fact finder. The facts of the case really don't change on remand. The only thing that changes is the historical evidence and briefing. And I think, our brief, as well as the helpful information added by amicus knife rights, is more than sufficient to meet the burden to demonstrate that they are arms and that they do not fall within any of the four delineated exceptions. And one other point I would make is that in Bruin itself, there was not a remand. And actually, one of the points that Justice Breyer made in dissent was that he would have preferred a remand, but that was not the part. Those were not the facts that he wanted additional evidence on. He didn't dispute the U.S. Supreme Court's ability to do the historical research. He wanted more information on how the regulation scheme worked in practice, because that was a challenge to a regulation scheme that had discretion. Whereas here, given the wording of the statute, anyone who wanted to carry a switchblade for self-defense would be prohibited from doing so, which is why the statute amounts to a complete ban. But
it's not a complete ban on knives, and I guess I wanted to give you the opportunity to address that question.
It is not. That's correct. It doesn't ban all knives.
So
but
isn't it different than, well, that's the argument, is that it's different than a total ban? What's your response?
No, because I think it's a total prohibition on a subset of knives, much like the regulation in Heller was a total prohibition on a subset of firearms, specifically handguns. I mean, the Heller regulation didn't prohibit, for example, hunting rifles or shotguns. It only prohibited handguns, much like the regulation here. It prohibits a subset of knives, which is switch knives, to use the terms in the text, or spring-assisted knives. But the reason it's an absolute ban is because it applies to every single person in all circumstances, wherever they are.
Does that fit in with the usual Second Amendment debate about reasonable restriction, right? Because if we have firearms, that's one thing. Then we'll argue about extended magazines at some point, and you know where I'm going with this. So if we allow someone to carry a buck knife or a regular folding knife, and we say, well, reasonable regulation is you shouldn't have a spring-assisted, essentially folding knife, how is that not a reasonable restriction?
I think there are two parts to the answer. The first is that it does not fall
But we're
within,
talking about milliseconds from when I can yield yield the blade, right?
I'm sorry, can you
We're
say that?
talking milliseconds from the time I can either quickly do this with a buck knife or press a switch, right? So why isn't that a reasonable restriction?
Because it is an absolute ban on having it in any
So is a ban,
circumstance.
so is a ban on extended magazines. That's an absolute ban. You're not answering the question, why is that not a reasonable restriction?
Respectfully, it's not a reasonable restriction because it doesn't fall within one of the four categories outlined in Bruin Prong 1, and because the Commonwealth hasn't shown a historical tradition of regulating similar to that. From everything I have found, although I don't think my burden is on that prong, switchblades were never banned prior to the 1950s in any state, let alone at the federal level. There may have been some evidence of concealed carry bans, but they were not absolutely prohibited, and given there are four exceptions to what constitute protected arms, and that includes, for example, regulations on classes of persons who can carry it, right? Like the language that Bruin uses is felons and the mentally ill, although I don't know that I'd phrase it that way.
Right, in the unusual, et cetera, right?
Right.
If we go through that.
Or sensitive places.
So why isn't the switchblade the functional equivalent of the sawed-off shotgun that's quickly available and within a short distance has a broad spray?
Well, I think I can answer that mechanically, but my sense is that your question is more, why isn't this dangerous and unusual, much like a sawed-off shotgun might be? And I think my response would be first, and correct me if that's not the question, under the Bruin formulation, in order to be an exception, an arm must be both dangerous and unusual. I think given that handguns are not considered dangerous under this formulation, it's quite hard to argue that switchblades are somehow more dangerous than handguns or electrical weapons, which from the decision in Ramirez, I think outlines a number of the dangers associated with
But
stun
I think the
guns.
firearms are not considered dangerous. They're just not unusual.
That's the purpose of a firearm.
Right. And I guess you would argue that switchblades are also, not that they're not dangerous, it's just that they're not unusual. And it's a conjunctive test.
I would argue both that they are less dangerous than arms that have
Well,
been
less
found to be
dangerous is
protected.
not the test. The test is dangerous and unusual, right? So
Correct.
it's dangerous.
Yes, of
All right,
course.
thank
Any
you.
weapon can be dangerous.
But it's not unusual.
Yes,
Yeah.
essentially.
I'm sorry, please, Chief.
Okay. I thought you said, I'm still confused about who you think has the burden to show whether or not this is an arm. And I thought you said that you don't, but you did. And then I thought you said that you did have the burden. So could you just explain?
Yes, I see where I was unclear. So I do think that prong 1 is the burden, so to speak, of the moving party. So that would be my burden to show that it is an arm. Where it is not my burden is to show that the regulation in question is consistent with the nation's historical tradition, which I think there was a prior question that sort of bled over into, is this a reasonable regulation? Which it's kind of a strange test because there's a bit of inquiry into the history of regulating and the purposes in the determination of whether something's an arm, but that question I think actually goes more to prong 2. Is this a reasonable regulation? Because prong 2 requires the government to show that the regulation is consistent with the nation's historical tradition.
And so that leads me to my second question, which is, you said that the Commonwealth didn't show that, but that's why the questions, you got the questions about why shouldn't this be a remand so that the Commonwealth has an opportunity to show that. And you said, no, you have enough information, but I mean, that may not be the Commonwealth's view on it.
It may not. I would just note that really no party addressing that question has found any regulation whatsoever prior to 1950 that is akin to an absolute ban. It doesn't even really seem like the parties disagree that switchblades were not banned until the 1950s, so I'm not sure what benefit a remand would have solely on that prong.
Can I ask you where that fits in the Bruin analysis? Because when we get to Bruin and say we do this ourselves, right? And we don't remand it, we look to see what the functional equivalents of folding knives, I think. And if you look at the Ninth Circuit case, that's what they do. We look at historically, how the country has treated folding knives and then assisted folding knives. But then the next layer that you discuss is how it came to be in the 1950s, and I guess after West Side Story, that switchblades were banned. Does that fit into the reason for the ban? Does that fit into the Bruin analysis? And where does it fit in?
It is a bit tangential, to be honest. I think it fits.
It's interesting.
Exactly.
But I don't know where it fits in legally. That's why I'm puzzled.
I think my instinct is that it fits in prong 2. But I tend to agree that it's more of an interesting tangent than fitting neatly
I don't
within
even
the
know if it's
Bruin.
relevant because it didn't exist back then, and who cares under the Bruin?
I think it's relevant under prong 2 in that prong 2 asks us to look at the nation's historical tradition of regulation, which is to say, how has this weapon been regulated through time? And I think, the government has pointed towards some case law about the purpose of Section 10B. There's the appeals court, Miller. Strangely, a number of relevant cases are all called Miller. And the Miller case just said the purpose of Section 10B was to ban, I think the direct language is, knives that are suited towards stabbing human beings.
Aren't all knives suited to stab human beings?
I would think so, yes. But I think it's...
Let me ask you, so, and then do we get into the reasons surrounding the statute, which are not all that pleasant in their ethnic and racial components?
I think that's correct. Because, there is case law saying the reason for the ban is this. They are dangerous, but if we look into why they were banned, we ask ourselves, well, why did people think they were dangerous? Was that an evidence-based conclusion? Was that realistic, or was that based solely on stereotyping?
But you think this fits in, at least in some respects, into the Bruin analysis?
Not neatly. I think it is relevant to prong 2 when we are analyzing whether it's consistent with the nation's historical tradition. But I don't think it's dispositive, if that makes sense.
Right, so then if this case were to go up, then the issue would become, well, why did you look at the 1950s legislation? You should have stuck with your tri-cornered hat and looked at the founding, correct?
That is our position.
Right.
Well, and isn't it relevant that until the 1950s, so far as the government has shown, these weapons were not regulated?
Yes, it is relevant. That is why the government has not met its burden under prong 2, and that is why the statute is facially unconstitutional.
Okay, thank you very much.
Thank you. We would ask that you reverse the decision of the trial court and overturn the conviction. Thank you.
Okay, Attorney Martino.
Good morning. May it please the court. Elizabeth Martino, Assistant District Attorney on behalf of the Commonwealth. And the Commonwealth is asking that the court affirm the trial judge's denial of the defendant's motion to dismiss.
And you're also asking for a remand, right?
Our primary position is that this court can affirm the denial of the motion to dismiss.
So assuming that that is not going to happen, what would you do on remand since you've now joined the AG and asking for it?
So just for clarification purposes, we did join as that remand could be an alternative remedy, but that, first and foremost, we're arguing that affirmance would be proper on this record. And that's because the defendant in this case...
Can you answer why a remand would be appropriate as a secondary option?
Of course. The defendant has the burden of showing that the weapon in question is protected, covered by the Second Amendment. And
where does that come in Bruin? What page does Bruin say that?
Yep. So it's not explicitly stated, but in Bruin and in Heller and in McDonald, the Supreme Court says that the covered weapon, the protected weapon by the Second Amendment are those that are in common use today for self-defense. And it's a prima facie showing by the movement, the proponent. And
that's the part that I'm wondering about. Where is that in the case law?
Yeah, so
prima facie showing by the movement.
Yeah, that's well, again, it's not quite explicit, and I think there's a little bit of a ability to argue both ways. But I think that most courts are accepting that it is, most lower courts that it is the movement, and I think even, an argument my sister did say, I would accept that it is our initial threshold showing, the defendant's threshold showing that the weapon is covered by the Second Amendment.
And under the First Amendment, whose burden is it to show that something is not covered speech?
I don't know off the top of my head. I would argue.
Would that be an appropriate analogy for the Second Amendment?
I mean, yes, I think probably, because the rights, and again, I'm saying probably and hedging a little bit because I haven't really analyzed that, but I would think yes, as both the First and Second Amendment are co-equal rights. And I think, the language of Bruin, and I just find it for your honors, but it is that there's a prima, once the movement has established that a prima facie, that the weapon is covered, is protected by the Second Amendment, then the burden shifts to the government to show a national history in its laws of regulating the weapon.
So do you think the remand would be required as a secondary option for the defendant in this case to show that it's an arm, or do you agree that it's been shown?
No, that's our primary contention, is that it has not been shown to be a weapon in common use today for self-defense.
Well, aren't we using the Heller definition of arm?
Which was reaffirmed in Bruin, right?
So I don't get how we don't get past that, how that's an issue here. If you read, you of course have, and as counsel explained earlier, the definition of arm is anything carried on the person to protect oneself, essentially.
Well, I think that's a dangerous definition, right?
Well, it's not mine, it's Heller's. I didn't write it.
Well, in Heller, to be clear, in Heller, nobody disputed that the handgun, it wasn't the first prong that was disputed, neither in Heller or Bruin. So it wasn't really litigated.
The text doesn't say firearm, it says arm.
Absolutely. But there was no question that the firearm, it wasn't disputed that a firearm was a weapon covered by the Second Amendment because of its common use today in self-defense.
Tell me, of all these knife cases, which are a lot more than I thought there'd be, that have been decided by lower courts and circuit courts, any one that has rejected a knife as an arm?
Right. So the only case that we have post-Bruin is the Ninth Circuit Teeter case, which is cited in the knife amici and the CDL amici.
Right.
That case is actually, there's been a petition for rehearing, and it was joined by 16 states and the District of Columbia, including Massachusetts, because of the sort of summary way that the Ninth Circuit treated the two-part test without analyzing first and carefully the first prong, which is whether these butterfly knives meet the definition of an arm and are thus covered under the Second Amendment.
If you think Heller is too broad, what definition of arm should we apply?
Yeah, it's the one I think that is put forth both in the Commonwealth's brief and in the Attorney General's brief, which is that it must be in common use today for the core purpose of self-defense. And what's wrong about it, or why the weapon in issue here, the switchblade, does not fall under that definition is the very nature of the weapon, which should be considered.
It's circular, though, because we've banned them.
No, but I'm not talking about, the numbers of ownership. I'm talking about the nature of the weapon, which the court said, in Bruin and Heller and McDonald, that you look at the nature and the use of the weapon. So a switchblade, by its very nature, is a lethal weapon whose lethality is concealed until the very second it's used to then injure.
So, all right, so is the buck knife that's in my toolbox.
Well, no, I'm sorry, the buck knife I don't know about. And this is,
The
again...
folded knife, you can use it to cut shingles, or you could use it to stab people.
Right, but you have to, the difference, I think, is that you have to unfold it as opposed to the switchblade. And so two things to answer your question. One is that...
Well, wait, sorry, just technically. A switchblade, you also have to unfold. You just have a spring-loaded mechanism to do it, as opposed to using the flick of the wrist.
Well, these are all sort of factual questions that aren't borne out in the record, which I think
Is that really
is...
something that the government's disputing?
No, I think that at this point, I think that this court can decide as a matter of law for the Commonwealth, but not against the Commonwealth. And this is why. Because the defendant pled guilty to having a spring-operated switchblade, which, as I'm pointing out, is by its nature non-defensive. It is, the lethality is concealed until the very last second, which is...
I don't know that I can join your rationale. Okay, just bear with me for a minute.
Yes, Your Honor.
Say you have the buck knife that Justice Gaziano is talking about, and you're being attacked. Do you want the knife that to defend yourself, that you're already in the midst of panic and angst, that you've got to try to figure out how to unfold it? Or do you want the knife that you can hit a button and it'll be deployed if you have to defend yourself?
So respectfully, Your Honor, I think that self-defense involves many things, including trying to avoid, actually hurting somebody.
That's retreat.
So-
Self-defense, the idea of trying to figure out whether or not this is in common use for self-defense,
Yes.
that it would seem to militate in favor that it is for self-defense, the more quickly you can deploy it.
But I think the reason that the handgun is the quintessential weapon of self-defense favored by Americans throughout the country today is its deterrent value, stop or I'll shoot, which is fundamentally different from the switchblade, which is, I don't got nothing until somebody comes and it's immediately lethal. It's the concealed aspect of it. It's the weapon of ambush, which is why it is fundamentally different than the handgun or the knife you may bear on your hip, which is self-defense because it is to deter violence.
So one of the things in Heller was that whatever the state statute at issue required the firearm to be disassembled in the home.
Yes.
And I think it was the majority decision that said that made it less helpful for self-defense. So I'm wondering why the spring-loaded mechanism isn't similar. The ban on the spring-loaded mechanism isn't similar to the requirement that the firearm be disassembled in the home.
Well, it's a point well taken, Your Honor, but in the same time in Heller, the plaintiff there did not say that he was disputing the use of trigger locks and, ways to store your weapon to keep it safe, right? So, but keeping it completely disassembled and the requirement of the law to keep it completely disassembled rendered it essentially inoperable. But they were not challenging safety mechanisms, trigger locks, things that keep it safe from the child walking in. Think of the switchblade. It does not appear lethal. It has no deterrent effect. And in fact, you leave it on the table and a 4-year-old comes in and plays with it.
Under your logic, that'd be okay to ban concealable handguns, and everybody would have to carry a long gun or a long rifle for self-defense, right?
Well, I think it's
because
just...
quintessentially a firearm's concealed on people, or a handgun is at least.
Well, until it's pulled out, and then its nature is immediately apparent as a lethal weapon.
I just don't get your distinction between, of course, and we look at the rest of the country, and the rest of the country has no ban on switchblades, or most of the country.
Well, respectfully, I think there are many jurisdictions that still do. The AG listed them out helpfully, but I think first and foremost, it's the Commonwealth's contention that as a matter of law, the defendant has failed to show that this weapon is a weapon commonly used in self-defense today. It is the antithesis of self-defense, and in fact is the purpose of it as a lethal weapon is concealed until the last second, where a press of the button immediately renders it a lethal weapon, and that it's no deterrent value, unlike the handgun, which in the cases, the only binding precedent on this court, handgun is the self-defense weapon of choice. I think it goes to the point that...
I think you're reading self-defense narrowly as well. As Justice George has posited to you, it's not just deterrence, it's you're being attacked and you need a weapon.
Yeah, any weapon can honestly be defined as a weapon of self-defense. A rocket launcher can be used in self-defense.
But then we get into the other unusual, we get into the other parts of the exception.
We do, but
where if you go through the statute that we have, some of those items on the statute probably wouldn't hold water under the rest of the statute, but this might be different.
Yes, I think I think that the record as it stands does show that this is not the type of weapon today commonly used for self-defense. That's the main argument. If the court should disagree and think that,
Know that we know, because it's the same question that began your argument from Justice Wendland, or that was asked of your sister. We just have a number of how many are manufactured. That doesn't tell us whether or not people are commonly using this for self-defense. It certainly doesn't tell you that in Massachusetts, because you can't have them. But I mean, it seems that you need a record to develop it. You've made a couple of statements that talked about what the only purpose of switchblades are. Well, what's the evidence of that? Where is that from? We don't know. And when Judge Stanton, wouldn't that be a wonderful thing to have in front of Judge Stanton to talk about all of these different permutations and implications?
yes, Your Honor, which is why I think with the, AG's brief, we did join that as an alternative remedy. It's not, I don't think, necessary on this record because of the nature of the switchblade, but should the court disagree, I think a remand could be useful under the circumstances, especially where this case can have broad implications, in the Commonwealth. If, for example, the court were to follow the Ninth Circuit in the Teeter case with the butterfly knives and find, as a matter of law, all bladed weapons are covered by the Second Amendment. That case has been used now to launch many, many, many attacks on legislation of assault rifles and, lots of different weapons throughout the federal court system.
I might have missed that in that case. Did it say all bladed weapons or just say butterfly knives?
It said butterfly knife is a bladed weapon and as such is covered by the Second Amendment without any analysis as to the weapon itself.
So if there is a remand and the defendant meets its burden, if indeed it is the defendant's burden on whether it's an arm, on national historic tradition, do you look at anything after the passage of the 14th Amendment?
I think the relevant inquiry is between the founding and the passage of this, the Second Amendment and possibly into the 14th Amendment. And I think in terms of,
I mean, post 1868, does that matter?
no,
What about the reason for the ban? Does that matter?
I'm sorry, Your Honor?
The reason for the ban in the 1950s?
So I think that can only be relevant, and I agree with my sister with the term tangentially. I think it can have some relevance to show that I don't think that spring-assisted switchblades were common in the 17 and 1800s, and that is a modern development of knives. And as that modern development proceeded, a rise in, the legislature saw a rise in crime and then decided to outlaw that type of weapon. To the extent that a court looks at, was this in common use at the time, and is this just a modern development of that? I think, you can look at sort of that, yes, it is a modern development of pocket knives that were in existence in the 17 and 1800s, but as that, modern development came about, legislatures noticed that they were dangerous and limited their use. Does that make sense? But in terms of, does it fit into the nature, the nation's history of legislation, so that meeting the Commonwealth's burden? No, because it's not about the relevant time period.
Okay, so the remand would only be about the question whether a spring-loaded pocket knife is an arm.
No, Your Honor, it would also be about the relevant historical legislation. And in footnote 6 of the Bruin decision, the U.S. Supreme Court said that trial judges at the evidentiary level are tasked with determining, 1, whether a weapon is in common use for self-defense today, and 2, whether the historical legislation is analogous, is a historical analog. So they specifically said...
Right, but I'm just saying, for this particular weapon, you're not aware, standing here today, of any evidence before 1950 that this was in any way prohibited. And you've looked.
No, but I think that that's because this...
And you've looked.
Yes, but I think that's because this weapon is a modern development of pocket knives, so there is a little bit of a difference. I do think that historical analogs exist and are cited in Bruin itself of limiting concealed carry of weapons, and especially certain classes of weapons that were considered sort of like not honorable weapons, dirks, daggers, Bowie knives. And I think that the switchblade falls into these sort of different kinds of knives that weren't, that were regulated from the founding. And also the switchblade, the nature of the switchblade as a concealed weapon. I think the historical analogs, which are in Bruin, in Massachusetts and New Jersey, of limiting concealed carry can be applicable to the case here.
But is 10B a prohibition on concealing a switchblade?
Well, I think the reason it's an analog is because a switchblade in and of itself is a weapon of concealment.
Because the blade is concealed?
Yes.
Just like a pocket knife?
Yes, but I think the difference here is, and we're looking very granularly under this test, and I think importantly, because and I will, with the permission of the court, perhaps, include the petition for rehearing under Teeter, because it shows, it's a good summary of all of the challenges to all these different types of legislation based on Teeter out of the Ninth Circuit, because it was such a broad decision. All bladed weapons are covered by the Second Amendment without a granular analysis of the actual butterfly knife in question.
This was a conditional plea, right?
Yes, Your Honor.
Do you agree if there was a remand that would all stay the same?
I think,
In other words, there couldn't be a withdrawal or a higher sentence?
no, right, absolutely, yes, Your Honor.